Alfred, always a pleasure being here.
And I told our viewers and our listeners on 3FM that if they recall, just some 3 weeks ago, you indicated that specific to Article 146,
Yes.
10A of the Constitution, the President was clothed with the powers of what has happened today. Let's just backtrack a bit and put the matters in context. Exactly what has happened today and the power of the President taking this particular decision.
Precisely so, Alfred, because we just had to indicate what was possible under circumstances and what was not possible. And we saw that it was possible for the President, along the line in this process, he has that power to suspend the Chief Justice so that the process can still continue. And that's, we have seen, that has played out today. And mind you, I think last week or so, the minority had raised concern. I think they had picked some intel that this was bound to happen. They had already raised concerns that they were opposed to it. But we also did indicate that before the suspension could happen, some things needed to happen before.
Indeed.
Because at that point, we had only got information about the fact that the Chief Justice had put in her response to the petitions. And we felt that at that point, it was still premature for any suspension to have been carried out. Because, one, when you look at the procedure, there has to be the establishment or the otherwise of a prima facie case. And if the prima facie case is established, a committee will be set up, and then the matter referred to the committee before the suspension can now kick in. So the letter we got today from the presidency did indicate that all these things have happened. And we've now found ourselves at the point where the president exercised the power that he has under Article 146(10) of the 1992 Constitution, which is clearly displayed on the screen here. And it says that where a petition has been referred to a committee under this article, the president may. So it's an option that the president has to do it or not to do it. In this case, he has. May A, in the case of the Chief Justice, and that's what we are dealing with, acting in accordance with the advice of the Council of State. Mind you, the president didn't do this alone. He had to consult with the Council of State to come to this conclusion. And by a warrant signed by him, suspend the Chief Justice. That is what has happened today. And that's the communication from the presidency to the effect that the Chief Justice has been suspended. Alfred, it's instructive to also indicate that the power given to a Chief Justice to suspend, the Constitution also gives the President power to revoke that suspension anytime. And I'll show you that in Article 146(11).
I see.
Which says that the President may at any time revoke a suspension under this article. To put this in simple terms, we are told that the Chief Justice has been suspended today.
Yes.
We may wake up tomorrow morning, and if the President deems it fit, he can revoke that suspension.
I see.
It doesn't have to depend on anything, as you can see. That's all that the provision says. So the power to suspend and then the power to revoke that suspension.
The same suspension is vested in the president.
Exactly. It's like the power to appoint and to, as many would like to say, disappoint. So in this case, the power has the president the power to suspend, just as we have seen him do, and then that power to revoke that particular suspension. So it's not a done deal yet, as many may have thought, that once the suspension is on,
then the Chief Justice is a goner. So
yes.
It's just.
But even in furtherance to that, mind you, the Chief Justice is going through a process. It's a legal process. And this is at a point where the President, in consultation with the Council of States, have come to a conclusion that, yes, there are issues to be responded to, or there is a case to be answered, or that there is a link between the allegations made against the Chief Justice, so much so that she's called upon to answer. If she answers favorably, and that committee, as would show who the members of the committee are, as has been put together by the President and the Council of States, if the committee comes to a conclusion that, yes, the Chief Justice has responded favorably, for which reason she does not deserve to be removed, such recommendations will be made to the President. And as the law is, the President is bound by such recommendations.
I see. It's instructive that you make this particular point because, that 146(11) that you reference essentially indicates that the President could just, decide that, look, I'm recalling this suspension, reinstating her as the minority essentially is demanding. But if you listen to the likes of Samuel Kujato, renowned legal practitioner, he makes the point that he does not see President Mahama reinstating the Chief Justice, where this particular process has gotten to. We'll hear from him in a bit.
Yes, but so it's one thing.
These are divergent views.
It's one thing having a view that it's impossible, but in law, it is possible. And that's what we just shown you in Article 146(11). I mean, maybe once upon a time, no one thought that a president would invoke Article 146(10), because this will be the first time in the Fourth Republic we are seeing the Chief Justice being suspended under these circumstances. So you never can tell. It is possible, since the law allows it to be done, it's possible that maybe the president may change his mind and he wants to revoke that particular suspension for whatever reason.
I see.
But it's not all that gloomy. I mean, but of course, that's a view that he's entitled to.
Perfect. So what we are seeing now with the Chief Justice being suspended is not conterminous with our legal history. This is unprecedented. It's a precedent that's been set beginning today, because we've seen a number of Chief Justices in the past being petitioned, but it has never gotten to this point of they being suspended, correct? Let's go back into history.
Yes, that's true. So when you look at our history and as regards Chief Justices and how some petitions have come their way, yes, of course, we've seen that a lot of them have had to deal with petitions, or the president has been petitioned to take certain actions against them, i.e. their removal. But we haven't seen a point where it's got to a point where a Chief Justice, while in office, was suspended because of circumstances like this. Let's go back to 1991. So from 1991 to 1995, where we had Philip Edward Archer, there are no records of any petitions against him. Likewise for Isaac Kwabena Aban, 1995 to 2001. When you move forward to Justice Edward Kwame Redu, in the years 2001, 2003, there was a petition against him, and this was by one petitioner called Francis Janku Asasi Kofi. Now, the basis for this petition largely were that the Chief Justice had lied under oath about his age regarding his date of birth, whether it was 1934 or it was 1932, and that in doing so, the Chief Justice had deceived Parliament during a vetting to extend his tenure of office, and that by doing so, he had committed perjury by providing false information to a public office. Those were the basis for that particular petition. The conclusion was that the petition failed, but then Justice Edward Kwame Redu voluntarily retired. We also have the issue of George Kingsley Acquah, Justice George Kingsley Acquah, 2003-2007. The petition was brought against him by Bright Oblite Akwete. The basis were that there was some judicial interference, allegedly, that he was instructing judges on how to rule on specific cases, abuse of office, and then victimization of judges. The outcome, as we would see, that also failed. We move on to 2007 to 2017, two petitions against then Chief Justice Georgina Theodora Wood. The petitioner, citizens of La Home and abroad. The basis for the petition were that there were some allegations of unfair handling of land cases related to the Ga Adangbe people. The petitioner, there was another petition again. I mean, so in her case, there were two petitions. The other petition was by one Ernest Audrey Latte.
Right.
The basis was for stated misbehavior and incompetence. And mind you, these are the grounds stated in the Constitution for the removal of a Chief Justice. Fast forward to 2017 to 2019, Justice Sophia Kufu, petitioner was Mensa Thompson of Asepa. The conclusion, this petition failed. We go to Justice Enimi Yeboah, Asepa again as the petitioner. There was an allegation of some 5 million bribery scandal by a lawyer. This petition also did not see the light of day. It failed. Now we move to what we are having to deal with. 4 petitions. We understand there are 2 more petitions against Justice Gertrude Tukono. Aside those that have been dealt, or those that have been dealt with, we understand there are 2 more petitions.
So let me understand this. So we know there are 3 petitions that was announced by Felix Kwachofosu a little over a month ago in that press statement.
Those in respect of which the prima facie case has been established, for which the committee has been set up to look into the matter.
Perfect. And
3 of them.
Professor Kwekwa,
this was somewhere last year.
This petition was after the election.
Yes.
When Nana Akufo-Addo was still president.
Exactly.
And this was dismissed.
This was dismissed. This did not succeed. But the 3 of them that we are dealing with now have succeeded. Beyond those 3, we are learning that there are other 2, which have since been forwarded to the Chief Justice for her to respond.
So that makes it 5. In addition to this, essentially will be 6.
Yes. So in addition to this, will be 6 petitions in all against this particular Chief Justice.
I see. Now, that means that she actually, if you look at the historic perspective you bring to this, she is the Chief Justice with the highest number of petitions against her.
Precisely so. 6 of them in all.
I see. But then again, out of the 6, it's only, as we speak now, it's only 3 that have then had a prima facie established.
At least 3 of them have crossed a point where an inquiry will be made into. That is to say that a case has been established for which she has, or the Chief Justice has to answer. The other one has failed, so that is a goner. The other 2, we are waiting to see what the outcome of those would be, because what we are gathering is that they've been forwarded to a Chief Justice for her to give her response. Once the response is given, it goes through the process again. The President, together with the Council of State, would put the facts of the petition together with her response and also determine whether or not a prima facie case will be made of it. And if it's done, a committee to look into it. The question is whether or not it's still the same committee that will look into that same matter if a prima facie case is established, or a new committee will be set up to look into it. That's another matter. But Alfred, let's take a look at the members of this particular committee. We had already said in the past that the composition of this committee, 5 members, 2 of them must be justices of the Supreme Court. 3 of them, let's just say ordinary people, because they are not supposed to be lawyers. They are not supposed to be members of the Council of States. So, of course, you, Alfred, can serve on this committee. Unfortunately, I cannot serve on this committee.
Because you are
precisely
so. Of the court.
So, yes, Justice Gabriel Scott Palmer is the chair of this particular committee. He's a justice of the Supreme Court. Justice Samuel Kwame Adibu Asiedu.
He's the chairman of this committee?
Yes, he's the chairman of this committee.
But sometime last week, there was a petition against him.
Yes.
That the petitioner withdrew.
Yes.
Essentially. And now he's the chair.
And that's the interesting thing about life, Alfred.
Of this committee.
So what that means is that if that petition was allowed to go through against Justice Gabriel Scott Palmer, the Chief Justice would have been the one to determine a prima facie case against him.
And this time around...
But for the withdrawal, that process truncated. But it so happened that the petitioner decided to withdraw that petition. Now we have a situation whereby he has now been appointed to be a chair of a committee that will sit on the matter of the Chief Justice.
That's life, is it not?
The twist and turns. But he's one of the 5 members of the committee.
I see.
Justice Samuel Asiedu is also on there as a member, Justice of the Supreme Court. Daniel Yao Domelevu, former Auditor General, and also a member of the Oral Preparatory Team, now defunct.
Yes.
Then we also have a member of the Ghana Armed Forces, Major Flora Dalugu, also a member. We also have Professor James Sefa Jisa, who is an associate professor of the University of Ghana. So these are the members who are going to make an inquiry into these 3 petitions that have been brought against the Chief Justice. They will make recommendations to the President, and the President would act on that particular recommendation. In the meantime, the President has decided to exercise his powers under Article 14610 of the 1992 Constitution to suspend the Chief Justice. The question arises, does that mean Ghana is without a Chief Justice as we speak?
It's a question.
There's an answer to that.
In fact, it has gotten an answer already, but let's get the answer to it. Exactly what that the details of the Constitution say, because the legal and judicial architecture of this country abhors vacuum. And so certainly we should have something right now, is it not?
Yes, but many had thought that when the presidency released the statement about the suspension of the Chief Justice, that information would have been added. I recall our colleague...
acting.
Yes, acted. Our colleague Mawene Egbeta put that question to the Minister of State in charge of the government communications, and he explained that the judicial service itself has a way of dealing with such circumstances. So I understand that to mean that the judicial service will give a communication as to how to progress from this particular point. But when you look at Article 1446 of the 1992 Constitution, it gives a route as to how to navigate these things, because it's actually contemplated that there will be a time that there will be a Chief Justice who for some reason may not be able to perform, or that place may actually become vacant. So when you look at 1446, it says that where the office of the Chief Justice is vacant, or where the Chief Justice is for any reason unable to perform the functions of his office, A, until a person has been appointed to or has assumed the functions of that office, or B, until the person holding that office has resumed the functions of that office. This will apply to what we are dealing with now, because the person holding this office has been suspended. So until that person resumes that office, as the case may be, those functions shall be performed by the most senior of the justices of the Supreme Court. Shall be performed by the most senior of the justices of the Supreme Court. I think emphasis should be
put on there, because that gives us a clue, is it not?
Yes, it does.
The most senior of the justices of the Supreme Court.
Yes.
As we speak, per the justice of the Supreme Court, who is the most senior as far as we do know?
Well, so the most senior of them will be Justice Pwaberi.
Why is that?
Well, so let me show you how they stand as it is now. The justice of the Supreme Court. So here's it. So they are arranged in the order of seniority.
Okay.
From top downwards. So on top of it is His Lordship Justice Pwaberi. He's 68 years of age. Next to him is His Lordship Justice Gabriel Pwama, the man who is chairing the committee that is looking into this particular matter. Next to him is Her Ladyship Justice Avril Lovelace Johnson. She's 63 years of age. That's the third senior most. Next is Justice Imoro Tanko Amadu. You have Her Ladyship Justice Professor Henrietta Joy Abina Nyako Mensah Bongsu. She is 67 years. It follows in that order. His Lordship Justice Emmanuel Yoni Kolindi is there. Following him closely is His Lordship Justice Samuel Kwame Esiedu. You have His Justice Lordship George Kingsley Kumsin is there. His Lordship Justice Ernest Yao Jehu, 56 years. One of the youngest. Then following him, youngest in terms of age, actually.
Right.
But when you look at that order,
it's also important.
So his Lordship Justice Henry A. Kofi follows. His Lordship Justice Yao Dakwasari. His Lordship Justice Richard Ejefrim Pong. And he is the youngest when it comes to that order in the Supreme Court.
Perfect point. And beyond their ages as well, you look at Justice Pwaberi. How long has he been serving as a justice of the Supreme Court?
About 17 years, because he's been at the Supreme Court since 2008.
To date, 17 years.
Yeah.
So essentially, even beyond the age, in terms of service as the justice of the Supreme Court,
he should be the most experienced on the bench of the Supreme Court.
Interesting detail there. And then it's already that his name has come up strongly, even though there hasn't been any formal communication.
But when we look at the provisions of Article 1446, as we have indicated, clearly it falls on him, unless otherwise, that's what it is.